Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us, coming to you from the beautiful campus of Washington State University. This is the Compton Union building directly behind me. It's a little quiet around here. We're getting into finals out here at WSU. Gonna circle back on that Gator's guns case. We now have the order granting stay pending outcome in the Washington State Supreme Court. I've had an opportunity to digest it. I've had an opportunity to vomit over it a few times, and now I'm prepared to tell you about what I think is absolutely one of the most animosity-ridden opinions I have ever read in my entire career. So today, let's spend a few minutes and let's talk about the nastiest opinion you will read all year. Okay, so coming to you again from the Student Union building here at beautiful Washington State University, we're talking about the matter of State of Washington versus Gator's guns. As you know, an injunction was granted at a Cowlitz County Superior Court. That lasted all of 88 minutes before Supreme Court Commissioner Michael Johnston placed a stay pending an outcome on this argument right here. His Honor has now ruled, and yes, this injunction will remain stayed pending argument before either the Court of Appeals or the Supreme Court, inevitably where the arguments will be shot out of the sky. Now, I think it's fair game here at Washington Gun Law to talk and be critical of a court's opinion. They have every right to be critical of the arguments that attorneys make in their court, and we have the right to be critical of the rulings they make. We're going to deviate from that here a little bit because, well, Commissioner Johnston seemingly just has a big, fat bone to pick with every single lawful and responsible gun-owning Washington resident. He's got a big bone to pick with the attorneys that are representing him. He's got a big bone to pick with Gator's guns. He had a big bone to pick with Guardian Arms, and it is obvious when you read this opinion that this opinion is actually written out of personal animosity towards your individual freedoms. Now, for many of you who had the pleasure and or displeasure of actually watching what was supposed to be oral arguments on this matter, you will know that the good commissioner really did not give the Silent Majority Foundation pretty much any opportunity to talk and spent most of the hearing talking about himself and what a wonderful human being he is, how knowledgeable he is on firearms and all the research he has done. And I will tell you, two of the warning signs you really want to know is if a judge comes out on the bench and starts talking about how they're a firearms expert, or if a judge comes out on the bench and says, listen, I appreciate and understand and respect the Second Amendment. What's coming is the next however, and that is exactly what has happened here. Now, I also said that the judge really seemed to take this matter personally. Why do I say that? Well, maybe it's because the word I, rather than the court, appears in this opinion 41 times. As a matter of fact, the good commissioner spends the better part of this opinion going through a laundry list of historical analogs and history related to firearms, some of which appears to be accurate, some of which appears to be fantasy, and all of which candidly appears to be plagiarized. And we do have a couple of independent journalists right now taking a look at this because as I read this opinion, I swear I've read it before. Now, the judge did get the law right when it comes to what needs to be shown in order to grant a stay. And as he correctly pointed out, under Washington court rules, an appellate court may stay a superior court decision in certain civil cases after considering whether, one, the moving party has demonstrated that the appeal involves debatable issues, and two, after comparing the injury that would be suffered by the moving party if a stay were not imposed with the injury that would be suffered by the non-moving party if a stay were imposed. That is actually the case law. And where the judge came down on this is listen, I think there are debatable issues that come out of the Cowlitz County Superior Court ruling, and for that reason, a stay should be granted. Now, I'm not saying I agree with the ruling, but I am saying that that ruling is legally justifiable. But what we're going to talk about today is all the vitriol, all the animosity, all the grandstanding, all the blowharding that Commissioner Johnston did in this opinion. Now, just to give you an idea of how personal this judicial opinion is, consider this. Having reviewed the party's briefing and attachments thereto, having thoroughly reviewed the Superior Court's decision, and having the benefit of oral argument, it continues to be my conclusion that there is no shortage of debatable issues in this case. To explain adequately why I believe this to be so requires an examination of 1, the historical development of firearm magazines generally, 2, the historical development of LCMs, 3, the mass shooting problem associated with LCMs, 4, the legislative response to that problem, and 5, multiple issues arising from the Superior Court's decision invalidating and enjoining the legislative process. Now, as I mentioned, the judge spends the better part of 20 plus pages writing a long historical thesis about the development of firearms and large capacity magazines, ultimately coming to this conclusion. The legislature picked an interesting number as the cutoff point. Why it chose the number 10 is uncertain and may require some legislative history research. But that number makes sense historically when considering that the M1903 bolt-action rifle holds 5 rounds in an internal box magazine. The M1911 pistol holds 7 rounds in a detachable magazine. The M1 Garand holds 8 rounds in an internal box magazine. And the Enfield SMLE bolt-action rifle is equipped with a 10-round detachable box magazine. And the Soviet-era SKS semi-automatic rifle in standard form holds 10 rounds in an internal box magazine. 10 is a reasonable number. Historically, soldiers and Marines won firefights with less magazine capacity, and it is reasonable to expect that a homeowner can ward off a burglar with 10 rounds with additional magazines on hand if the homeowner is relying on a semi-automatic firearm. Now, in addition to all of the animosity that we've complained about in this opinion, oftentimes those that are hell-bent on taking your inalienable rights will argue, well, what do you need that for? You don't really need that. If you don't need it, you shouldn't have a right to it, okay? And the commissioner here falls into the very same trap when he rules as follows. Gator's Guns apparently thinks the typical Washington homeowner needs more firepower than that wielded by Sergeant Cruz when he charged multiple dug-in positions manned by foes trying to kill him. Oh, and in the course of his research, of course, the commissioner became a ballistics expert as well. Take, for example, this footnote. It is commonly known that the 5.56-223 Remington can tumble when it hits human flesh and bone, causing catastrophic wounds. Rounds topped off with hollow point bullets compound the damage. The 5.56-223 Remington round is banned for big game hunting in Washington, such as deer and elk, apart from cougars, the cat, not the WSU student or alum. That's right. That's exactly what he ruled. And Commissioner, just so you know, that is true, that the minimum caliber to hunt big game is a .224. So the reason the 5.56 and the .223 Remington is banned for big game hunting is because the Department of Fish and Wildlife has determined that the round is not powerful enough for that purpose. It will shred or vaporize varmints, groundhogs, and such, as I witnessed back in high school when a friend used his AR-15 to blow in half a huge marmot. We stuck to paper targets after that. And I'm not really sure what's going on with the commissioner here. He probably does need to be investigated for animal cruelty, because let us also remember that during oral arguments, he basically stated that he had wiped out an entire species of squirrels in the greater Spokane Valley. Now, as we know, one of the most common arguments we get from those that are trying to disarm you is that, what do you need that for? You don't need 10 rounds, you don't need 15 rounds, you don't need 30 rounds, and if you don't need it, therefore you don't have a right for it. Ask the question of why do you need to go to church or why do you need to vote, however. As the court here ruled, compelling data provided by one of the state's expert witnesses, Lucy P. Allen, shows that the average number of rounds extended in a civilian defense shooting is 2.2. And of course, you know, His Honor, who now is become one of the foremost experts on firearms and ballistics in the state of Washington, well, he agrees with that as follows. The 2.2 statistic makes sense. In my 20 plus years of reviewing thousands of criminal cases from all over Washington, I could not recall a single instance where an individual civilian and a criminal perpetrator engaged in a sustained firefight. Well, there you have it. I mean, if the commissioner's never seen it, that really should be the end of our inquiry at that point, right? And I mentioned earlier on that there is a lot of animosity directed towards Gator's Guns for having the audacity to bring this lawsuit, and there's a lot of animosity directed towards the Silent Majority Foundation for having the audacity to represent Gator's Guns. Take this quote, for example. Regarding such weapons, Gator Guns seemingly favors semi-automatic handguns, preferably with LCMs, and at oral argument I expressed the admiration of the M1911. But one could reasonably disagree. A revolver is more reliable, easier to use, and the intruder can see that it is loaded, preferably with .357 Magnum or similarly powerful cartridges. That particular issue is beyond the scope of this discussion, but deserves some fleeting mention. And then I also said that rather than saying, hey, the lower court ruled as follows, and I disagree with it, you know, the way that every other legal opinion has ever been authored in the history of the United States. No, instead the commissioner here decides to keep taking shots at Gator Guns for having the audacity to have been able to convince the Superior Court of the righteousness of their arguments. Take this, for example. Relatedly, Gator Guns seemingly persuaded the Superior Court that the statute bans standard capacity magazines. This is a red herring. Whether a magazine is standard depends on the manufacturer's marketing. Yes, a semi-automatic firearm may come in the box equipped with an LCM as the manufacturer's marketing team intended, but it is quite capable of working with a 10-round magazine also. Such lower capacity magazines are cheap and plentiful, and firearm manufacturers have shown a ready willingness to conform their products to state firearm regulations. The standard capacity magazine argument gains no traction here. Now, if you all want to know where this case might actually be going from a legal standpoint, consider this. I believe that this commissioner, and I believe a large majority of the Washington State Supreme Court, will also believe that magazines are not even protected under the Second Amendment at all. They're not protected under Article 1, Section 24 of the Washington State Constitution, and they can be banned because there's no constitutional protection of them whatsoever. Don't believe me? This is what the commissioner ruled. Gator's Guns further persuaded the Superior Court that an LCM is an arm falling within the protections of Article 1, Section 24 of the Second Amendment, a potentially dispositive issue. One can argue that an LCM is a weapon if you whack someone over the head with it, but in reality, an LCM is an optional component of a firearm, not a weapon or arm standing alone. Now, some of you may recall all the videos that we did about Oregon Ballot Measure 114, and as we know, there has been two rulings. One out of Harney County, Circuit Court down there in Harney County, Judge Rashu, who has enjoined the law. The law has remained enjoined. And then there was also an argument made before a federal court, similar issues, that was denied. Of course, the commissioner believes, well, that one, the one that denied the challenges to Oregon Ballot Measure 114, is perhaps one of the most well-reasoned opinions he's ever read. The Federal District Court decision in Kotek is most persuasive on this issue, concluding an LCM is not a bearable arm under the Second Amendment, consistent for the most part with the foregoing analysis. While I am mindful Kotek is currently being appealed in the Ninth Circuit, it cannot be ignored that the threshold question of whether an LCM is an arm for purposes of constitutional analysis is more than debatable. And then, of course, the commissioner believes that the common use test actually has many, many more steps to it in common use for self-defense. And again, this gives you an idea where the Washington State Supreme Court may go with it. The commissioner ruled, furthermore, this court held that the right to bear arms under our state's constitution protects instruments that are designed as weapons traditionally or commonly used by law-abiding citizens for lawful purposes of self-defense. Oh, and one of the other things that the commissioner believes, yeah, he's not even certain that the Bruin opinion has any application in the state of Washington at all. Don't believe me? Well, this is his ruling. The court concluded the state failed to provide such history, in effect a 1791 regulation analogous to a ban on LCMs, a type of magazine that would not come into being for more than a century. Well before reaching that result, the Superior Court recognized that this court has not yet examined the teachings of Bruin in relation to Article 1, Section 24. The Superior Court then proceeded to fashion what is in effect a new Article 1, Section 24 test revolving around Bruin. Although that is quite an interesting approach, this court, as the final arbiter on state constitutional questions, will need to weigh in on the issue, as well as the threshold and potentially dispositive questions of whether an LCM is an arm at all. Again, this is a debatable issue. And one of the other things that the court is pointing out, and this is a way where the Silent Majority Foundation could really get pounded on here, is the commissioner here is questioning whether or not the plaintiffs have even preserved Second Amendment arguments, or are they going to have to exclusively argue this under Article 1, Section 24 of the Washington State Constitution. The threshold question on the Second Amendment issue is whether it was properly before the Superior Court at all. It seems Gator Guns raised the Second Amendment as an affirmative defense to the state's separate Consumer Protection Act, which later was consolidated with Gator Guns' actions for declaratory and injunctive relief, which was based solely on Article 1, Section 24 of the Washington State Constitution. Gator Guns seized on the consolidation to assert the Second Amendment offensively via its motion for summary judgment, and the Superior Court obliged that strategy. So ultimately, Where the commissioner went with this is this. In any event, the issue of whether an LCM is an arm at all is a very large anchor pulling on the Superior Court's debatable Heller analysis. As for Bruin, and again ignoring for the moment the hugely debatable threshold question of whether an LCM is an arm, the Superior Court applied that decision's historic analogy test in a manner that is arguably extreme. Now, just to wrap all of this up and just to make sure that you can understand how personal Commissioner Johnston is taking all this, and let us remember that he wasted about 3 minutes of everybody's life during oral arguments talking about what? Yeah, that's right, talking about what we put on our YouTube channel, an absolute horrific waste of time. But to give you a more flavor of where this commissioner is coming from, check this out. Furthermore, as I quipped at oral argument, Washington is not protected by a force field. Just because a shooting happens on the other side of the country does not mean it will not happen here. And there is no magical screening mechanism for identifying a potential mass shooter when they walk into Gator's Guns or another shop to buy a multi-pack of 30-round magazines or 1 or 2 100-round magazines. And you remember that one of the big beefs that the commissioner had is, hey, I don't even believe that Gator's Guns is suffering any harm here whatsoever. That's right, you strip them of their inventory, but hey, we are not harming them at all. Remember, the commissioner wrote in this opinion as follows. Gator's Guns counsel at oral argument pointed out that its owners is an individual firearm owner affected by the current stay. To be more precise, he is an individual firearm owner who owns a shop storing thousands of LCMs. If he failed to add to his personal stash of LCMs during that 90-minute window, that's on him. And then couple that with the fact that all I read in there is I, me, you will see that this is in fact the nastiest opinion you will ever read. Listen, we're going to go ahead and link it all up down below so that you guys can geek out on it for yourself. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is down there in the description box. Let's everyone remember that if you got a video idea, go ahead and click on that link right there, because some of the best ideas we had weren't really our ideas. And then finally, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about here all the time, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. From the beautiful campus of Washington State University, thanks for watching and stay safe.